So there's a whole world of law related to people who can't make legal decisions on their own or don't have the capacity. One area that is special needs, and then there's elder law. And we're excited today to have a chat with a friend, Jason Sadow, who's referred by a key vendor of mine, and he operates his law practice in the state of Nevada, focusing on elder law, estate planning, guardianships, and probate. Jason, thanks for your time today.
Thank you for inviting me.
I know one of your passions is the law related to special needs children, which I guess would be guardianships and conservatorships. Talk a little bit about the special needs, the needs that come up, and then the law that you can provide to help people through that process.
Sure. So I could tell you I got involved in that space because of my 22-year-old daughter who has special needs. And so never mind do I help people with those issues. I'm pretty empathetic to the issues they're going through, having gone through most of them myself. In addition to that, so I can help people get guardianships if they need to. Usually step in around at the age of 18 as children are becoming 18 and suddenly are adults. Parents are sometimes very surprised that they don't have the same authority that they did before their child was 18 as a parent, now that their child has turned 18 and they need to do things. Sometimes that doesn't happen for some time before they realize they have to step in. And then sometimes it happens very early on. Quite often when a physician says, do you have guardianship? I can't see you, I can't let you back, or I can't treat your child any longer. That's always an interesting red flag.
A problem, there's another whole world of situations where the child becomes in need of conservatorship. I was at court once when a family was sharing that their child had an automobile accident. So they're an adult child, but all of a sudden they can't make medical decisions for themselves, and they didn't have anything in place to deal with that. So that's a whole different level. So I know that there's the hard part of the law, and there's what you would call the soft part of the business, which is the relationships. I would imagine special needs, those soft skills become more important than they do in other areas of the law, typically.
It is very important. Obviously, navigating the legal system is important. If you don't take the necessary steps, you quite often get sent back to the square one. And sometimes people engage me after they've tried to navigate it themselves. Quite often, I like to step in as early as possible to make sure that there's no gap in the ability to make decisions as necessary. But understanding what services are available and who to reach out to in the community is also very valuable. And having gone through it myself, I understand what that looks like for most families.
If there's one area, I don't have a dog in this hunt. I'm not getting referral fee from you, but I just want to say, anybody's watching, if there's one area of the law that you don't want to do it on your own, it's conservatorships and guardianships. Like even if you think you would do probate, which I would try to talk most people out of, okay. But for sure, this is an area of the law that this is not for amateurs at all. And I used to go to court every day in LA, and I would see it's heartbreaking. People, trying to save money in a terrible situation, and it's just not easy. It's just not easy at all.
Well, and I talk about my daughter and folks who are just turning 18, and I step in quite often there. I also step in that scenario where there's an accident, or as people age and lose the ability to make their own decisions or want somebody to help them. But in many of those scenarios, if there's any assets, the necessary steps to maintain an accounting on an annual basis and make sure that you comply with the necessary reports to the court are just as important. And to start that alone and not understand the requirements and not have anybody helping you with those can sometimes cause a number of issues in the courts as well.
In California, regularly, I would see for conservatorships, court-appointed attorneys or temporarily the appointment of court appointments. Is that a common practice as well in Nevada?
So in Nevada, the protected person is always assigned their own attorney, typically from legal aid. That attorney is assigned pro bono, and they represent whatever the protected person wishes are. They do not represent the best interests of the protected person. They literally represent what the protected person wants. But they are also there to make sure that there's
Hold on a second. That's an important distinction.
It
I mean, I'm
is.
sure there's a lot of law behind that, but as a member of the community, I can imagine what it means. So one more time, the attorney appointed by the court, usually pro bono, legal aid type, they represent the person that needs the conservatorship or guardianship, and their job is what again?
To represent the desires of the protected person, whether or not they believe that those desires are in the best interest of the protected person. And I will use as an example, on occasion, an elderly parent who has suddenly, who's suffering from dementia, who is now paranoid and believes that their child, who's now their guardian, may be stealing from them. And so now we're looking at guardianship compliance and possibly pushing through a audit to make sure that those things are not occurring. When it's possibly very obvious or very clear that the child is working in their best interest. On the flip side, many years ago, there were a lot of liberties taken from protected people in Nevada, and those laws changed to make sure that they were no longer taken advantage of. Sometimes that works very well. Sometimes that is, I call it the pendulum has swung. The enforcement of the rights of the protected person are very costly to enforce when those are not necessary.
You know, a common case, at least here in Los Angeles, is Britney Spears. And I used to go to court daily, and whenever she had a hearing for her case, but every 90 days or so, there'd be a whole big protest, Free Britney. And on one hand, you know, you hear stories about how crazy people are and crazy things they do and running through money and not providing for their family. And on the flip side, you also hear cases of people being abused. And I think it should be a high bar that the state takes away your right to make decisions for yourself. And yet you can imagine that high bar creates all kinds of opportunities for abuse.
It does. And really it's a balancing act to make sure that you know, no advantage is being taken from those folks, and that they're being appropriately taken care of by whoever's going to be the guardian for them.
What happens when their desires are in conflict with what's their best interest? Does the court just say they're entitled to make their own desires because they're adults, or does the court restrict their desires, you know, say in financial matters or things like that?
So it really depends. Depending on how far they need to push, we'll have, you know, hearings, evidentiary hearings, and eventually the court has to make a decision if we're at odds between the parties. Most of the time, over a period of time, since it takes a while to get those hearings scheduled and evidence provided, usually we've been able to come to a reasonable middle ground where everybody agrees on how we're going to proceed. If that can be done, great, and that limits a lot of costs and a lot of court time. But if not, then the courts get to weigh in.
And so just to go back to one thing you said earlier, I was just kind of now sinking in. I think I heard you say that a protected party can't doesn't have legal resources provided for them. They have to choose their own. So I mean, just literally today here in LA, I had somebody where, you know, daughter's taking care of their parent. They have a power of attorney, which allows them to do certain things, doesn't let them say sell the property. They want to sell the property. They know they have the legal authority, so they need to establish a conservatorship. So she's asking me to refer to an attorney here in LA that does conservatorships. Are you saying in Nevada you can't make that introduction, that the party just goes to court on their own and gets appointed somebody? Is the process?
No, sorry. So if somebody has a power of attorney, and they've typically been nominated as a guardian anyway, the paperwork for power of attorney usually says that. So if they need special powers like that to sell a property, they can petition the court, and they have the highest nomination to step in temporarily and to get an order to do something like that.
Oh, when so the power of attorney doesn't give them the authority to sell the property, but they can ask the court to give them that special authority in addition to the power of attorney for that one purpose of selling the property.
It depends on what's going on. In your example, they didn't have enough authority to sell the property. They may or may not hear, depending on the documents that are provided.
Interesting.
Hopefully, if you do an estate plan correctly, especially if you know that there's a potential issue where somebody may be at risk for Alzheimer's or dementia or some variation of that, you can certainly grant a very expansive power of attorney, but not all powers of attorney are created equal. And you may or may not need to go to the courts for special permissions in certain circumstances. A power of attorney, of course, has the highest nomination to step in as guardian. When they step in as guardian, the court's going to allow a legal aid representative to step in for that protected person simultaneously, do an interview with the protected person, make sure that that is what the protected person wants if they're able to express their wishes.
Got it. Wow, very good. So, and of course, a key part of all of this is avoiding it with proper estate planning, as you said. And I imagine, in my mind, all parents of minors should have an estate plan, because what happens if you're not able to make decisions for your child? How do you get taken care of? So, which grandparents, who's going to take charge of making those decisions? And I would think even more important, if your child has special needs, to have those in place ahead of time. And then I imagine there's some sort of a crossover process where I think you mentioned in the beginning, where a special needs child goes from being a child to an adult. How does that handoff happen? Do they then go back in for well, I guess Nevada is different, I'm sure, than California, but in Nevada, do they go back in for an update as a conservatorship, or they change the status when they become 18 or 21, or how does that work?
Typically, or most often, you don't have to worry about a child with special needs because it's their parent raising them, and you don't need a guardianship during that period. Parental rights up until the age of 18 are fine. And then once the child turns 18, they're now an adult. And because they've reached the age of majority, then you can establish the guardianship. And so that's usually what we're doing there. However, if there's a guardianship over a minor, you can convert it to a guardianship over an adult as well. If somebody else had been taking care of them prior to the age of 18.
Got it. Well, I am sure there's a number of cases that I have anticipated. That's why you're there doing the estate planning on a daily basis. I'm just trying to introduce people to you. So, Jason, if somebody, particularly if they have special needs, children or family members, but in general, looking for help in the area of elder law and estate planning and probate, what's the best way to reach you if they have some questions?
Oh, sure. So you can reach out to us via phone, 702-249-0160. You can hit our website, sadowlawfirm.com, or you can email us directly. My email is jason@sadow.law.
Well, Jason, thank you so much for the update specifically on the special needs process, which I find fascinating. One of my good friends does elder law here in the LA area, and I've watched him as well. It's a fascinating area, and I imagine it's becoming more active as on the senior side as people live longer, and then unfortunately on the younger side, it seems like it's more common as well. So thank you for your work, and thank you for taking time with us today.
It's a pleasure being here. Thank you very much.